Ms. Marlowe, are we live? Okay, go ahead.
Thank you, Judge. Ed, to your knowledge, did 2808 Maple Springs LLC ever deliver to the title company a release running in favor of Jordan and Aaron Zatoon?
Not to my knowledge.
Okay. Can you explain to the court the role of the title plant in verifying the meets and bounds and the legal description of a property, it's particularly as would have occurred in this case?
Objection, Your Honor, to the extent this is calling for expert testimony. If he wants to talk about what the title plant did specifically in this instance, I think that's appropriate, but otherwise I think it falls into expert territory.
Yeah, it's just saying that you can talk about what happened in this case. He's not an expert, so he can't talk about what normally happens.
Okay. But, to my recollection, there was a problem. There was an issue with regard to the legal description. And I think that the property, I think actually another title company, I think we were presented with a commitment done by another title company that possibly the examination was based on meets and bounds, and the property that we're talking about, 2808 Maple Springs, has actually been platted since then. So our plant actually found the plat of the property, and I don't really, it wasn't something like, I don't think it was a big problem or anything, but we did, our plant had to find the plat and then correct the legal description in the title commitment.
And Ed, was that correction done prior to March 8th, 2021?
I believe it was done, yes, undoubtedly yes, but I don't know the exact date when it was done. I'm guessing somewhere about February 12th or 15th, somewhere in there. It was just in the first few days.
Who was it, Ed, that brought to your attention that there was a question about the accuracy of the legal description from the other title company and made a request in that regard?
I don't really know, because it probably wasn't actually said to me. It was probably said to Angela or Lori, and then came to my knowledge because someone's basically saying there's someone's complaining about this legal description. So when that happens, I'm not a surveyor. I don't know. I just called our plant, another gentleman named Rick Caruth, and he's our plant manager. And I was saying, hey, we may have missed a plat, or there's some talk about the legal description being invalid. And it was a pretty easy fix. As I recall, it was a fix that it was a problem that lasted maybe at the most one day.
And so, Ed, when that legal description was updated or corrected, would that have been incorporated into the paperwork of Trinity Title, in particular the title commitment?
Yes.
That Trinity Title issued?
Yes.
And so when that legal description, the corrected legal description, is attached to the title commitment from Trinity Title, what does that mean in terms of the what responsibility the title company is taking that the buyer is acquiring the correct property and the correct description of the property?
Yeah, in this case, it would have been that we were sure that we were dealing with the correct piece of property, so that Trinity Title our commitment would be accurate. We're sure that we're ensuring title to this tract or this parcel or these lots to the buyer. That's part of the equation. The other part is we examine not only the property, but we examine the people too.
And so, Ed, with regard to the legal description, if either party had come to the closing and tried to substitute a legal description that was not 100% in conformity with the legal description that was prepared by Trinity Title's title plant, would that have been accepted?
No, it's not. And
Okay.
it comes up in the sense that we issue a commitment. A commitment, you can think of it more of an offer than anything else, because we're offering to ensure this title to this piece of property under these terms and conditions, provided we take care of everything on Schedule C. But one of those terms and conditions would be where we've examined title, this is your legal description, and we will ensure that you have first lien position if you're a lender, or highest claim of title, I guess, if you're an owner.
And so how would that, in this case, have protected on the title commitment Versailles Dallas Inc. in the event there were any discrepancies in the legal description on the ultimate deed signed at closing?
Well, we couldn't accept, or we couldn't close or insure a deed that didn't have the correct legal description. And when I say correct, I would say the legal description that Trinity Title has examined. And so if there are any changes to it, well, then that's a different transaction. That's not what we're closing.
And at any point in time, up to and including March 8th, 2021, did the Zatoons or me as their counsel ask you or Trinity Title to make any omissions or changes to the legal description that your title plant had researched and created?
Not to my knowledge. And I think there may have been some discussion in the first couple of days that we opened title, but after that was sorted out, after we had the correct legal, then no, nothing happened like that.
And Ed, with regard to closing adjustments, if the closing had taken place, can you tell us whether or not it's your understanding that there would be closing adjustments when you're dealing with a statutory buyback and not a private sale?
Objection, Your Honor, lacks foundation. He said he'd never done a statutory buyback before.
If you can answer that, go ahead. But if you don't, if you're not familiar with this process, then I would encourage you not to answer.
Yeah.
Or if you don't feel comfortable answering this.
No, I would. My understanding of I kind of had to get up to speed on the statutory buyback because we had one in front of us. It was my understanding that things are not as negotiable. And just for example, the TREC contract, I used to be critical of them, but they're actually pretty 50-50. They split the rights between buyer and seller. If the seller loses the garage door opener, for example, well, the seller can come to closing and say, hey, we busted or what. I mean, the parties can, it's kind of made to flex for stuff like that. Also, like the day of closing, for example, that time is not of the essence on the day of closing on a TREC contract. That allows people to have sick kids or something happens and closing maybe doesn't happen. Maybe they show up with an expired driver's license. It doesn't mean this whole deal is going to be off. We can fix it. But on the statutory buyback, I'd just say it's just much less forgiving. It's basically settling. The settlement services we provide are settling under a kind of a legal scheme as opposed to a contract.
And Ed, with regard to, you talked about a TREC contract. If a TREC contract is, as had been proposed by Versailles, was worded to say Versailles and or assigns, and there was no other language in the form itself, would there be recourse against Versailles if the assignor did not pay the money or close?
Objection, legal conclusion, Your Honor.
And
Can I share screen, Your Honor?
you may.
Mr. Scott, this is the court reporter. I
Yes.
missed the very last word you said on your question. Would there be recourse against Versailles if the assignor did not pay the money, or what was that last word?
Or close.
Oh, thank you.
Oh, there we go. Okay, so that's, Your Honor, is Exhibit P-115.
Okay.
Although it's not, what's going on here? Seems to be stuck.
I apologize. Give me 1 second. Okay, go ahead.
Thank you, Your Honor. So Ed, can you see this, this survey that I put up on the screen, P-115?
Yes.
And you see it says that it was ordered by Versailles Dallas Inc. I'm sorry about the print, it's very small. It's the box all the way at the bottom where it says A&W Surveyors Inc.
Yes.
And is it your understanding that Versailles ordered this survey sometime around March 4th or March 5th, 2021?
That's my recollection.
Okay. And was it also your recollection, Ed, that 2808, before they would close, demanded or requested that the title company remove certain survey-related exceptions to title insurance?
That does sound familiar.
I'm going to object. I don't see any relevance to whether or not one party or the other performed on the buyback agreement based on meets and bounds, or whether survey provisions were removed from the title commitment.
Your Honor, I will connect it in a second.
Okay, overruled
So-
for now.
Okay, so Ed, do you see that the date on this survey, and again, I apologize for the small print, I'm even straining to read it, is 5/11/2021?
Yes.
Okay, so based on 2808 or Versailles' request or demand that the title company remove a survey-related exception to coverage, would you have been able to close title while awaiting the this survey, receipt of this survey that's dated 5/11/2021?
No, I don't believe so. If the contract and or the parties want us to provide a survey, well, that seems like a condition to close. And we obviously we can't, we're not surveyors, so we can't, even if you've ordered it timely or ordered it early or whatever, if we don't have it, we don't have it.
And so, Ed, throughout this process from February of 2021 through March, can you tell the court whether or not you had any phone conversations with Julie Pettit or anyone from her firm on behalf of the buyer of Versailles?
I don't believe I've ever spoken to Julie over the telephone. I think we did exchange emails in conjunction with producing documents, but also I may have, and I saw that she's communicated with Trinity, but I don't know that I don't think that I'm the, forgive me if I'm forgetting a conversation, but I don't think that I've spoken to Ms. Pettit.
Okay. And Ed, can you tell the court whether or not throughout this time you had extensive dealings with me with respect to this statutory buyback?
I've had more. Yes, I have. In fact, that's one of the things that kind of stands out about this transaction is it wasn't typical. And from the get-go, I think you actually even told me the statutory reference, and that's when I actually read the statute for the first time since I used to represent a volume tract home builder, but 2008 was rough on him, but that's about the last time that I've looked at RECLA. So
Ed, can you tell the court what my demeanor or approach was in my conversations with you? Because I'm being accused, or my clients are being accused here of refusing, of being uncooperative, et cetera. So what were your dealings like with me?
Objection, Your Honor, relevance. I just don't think it's relevant what Mr. Scott's demeanor was with Mr. Lang. The question is, who breached the contract?
Your Honor, I think they opened the door to this by making those allegations that we're not cooperating. We're trying to blow up the deal.
I see very minimal relevance of this, but if you can answer quickly, that's okay.
yeah, it seemed to me that the Mr. Scott was, judging from the number of times I talked to him well after 5 o'clock, I can tell that he was trying to do everything he could to get this closed. I know that, well, that was the temperament. I mean, we were basically being kind of hustle. We need to get this closed. And I believe that on more than one occasion, I heard about the fact that we can't have any delays because the Zatoons are not in their house, and they need to get this done. Like, there was just basically a lot of effort to make sure that we had everything that we needed in order to get to closing.
Mr. Lang, if you had numerous conversations with Mr. Scott, did you ever talk to him about this assignment and why it couldn't be signed?
Yeah, I think we did. In fact, I think I spoke to him at the time when I told Lori and or Angela that an assignment's fine with us, but the parties need to agree to it. Because I had that conversation with them, I also had that conversation with Mr. Scott. I know that they sent that email that was shown here a little while ago, but I also told Mr. Scott the fact that we need to, I think I told Mr. Scott, in fact, I know that I told Mr. Scott, the reason why we need to know this assignment is because we ultimately have to do a bring to date prior to closing to make sure that we can ensure title to the entity or person that is proposed. In other words, we can't have a deed to you and or anyone you find. We need we need a specific person as a grantee or an insured when we issue a title policy.
So Mr. Lang, let me just ask you, did Mr. Scott tell you that he refused to sign the assignment, or that refused to allow his client to sign the assignment?
I don't know. I don't think he did. I think our conversations were just basically, I would remind him, well, you need to get with the other side. You need to work that out, or the other side needs to, y'all need to meet. I'm not the, we can't
this is to me an extremely critical point in the trial, or a point in the case, not the trial, in the case. And so you're saying that he never told you his clients were refusing to sign the assignment? I mean, it's okay if he didn't, but it seems like that's what would have happened, but based on the emails, but I'm just wondering what he told you.
I think he told me more than once that this contract is not assignable.
Okay.
In fact,
that answers the question. All right.
Yeah, I can't.
Mr. Scott, you can proceed.
I don't think he ever said, we will not do this or something like that. There wasn't a dig your heels in the ground, but I know that he explained to me that this wasn't assignable.
Okay.
So, Ed, would it have been, if Versailles had purchased the property and completed the statutory buyback, was it possible to do a simultaneous closing in which they could immediately transfer title to 2808 Maple Springs or any other buyer or investor that they wanted?
Objection, legal conclusion, Your Honor.
Sustain.
Ed, at any point did the buyer Versailles confirm a closing date with Trinity Title?
No,
At any point, did Versailles or El Chami wire any funds to Trinity Title?
no,
At any point, did a man named Kenneth Lambert wire any funds to Trinity Title?
no,
At any point, did Kenneth Lambert or 2808 set a closing day?
no,
At any point, did any entity or person purporting to be the buyer of the property at 2808 Maple Springs ever wire any money to the title company?
no.
I pass the witness, Your Honor.
May I proceed, Your Honor?
You may.
All right, Mr. Scott, will you stop sharing screen? All right. Okay. Mr. Lane, can you see my screen in front of you?
I believe so.
Okay.
Is email now a tax certificate?
Sure. You're quick. All right, I'm showing you what is part of Exhibit 118. Is this the settlement agreement that you indicated you had reviewed? And let me zoom in a little bit.
Yes, ma'am, it is.
Okay, and you see that on bullet point 3, it says Versailles and/or assigns.
I see that.
And as you indicated, it's very common in your business for contracts to be assigned, correct?
That is correct.
And despite what you saw in bullet point 3, you thought this contract was not assignable because that's what Mr. Scott told you, true?
Well, yeah, yes, but I don't know if it's only because of what Mr. Scott told me.
Okay. I want to show you, well, before I go there, it was Mr. Scott who submitted this order to Trinity Title, correct?
Yes, it was.
It wasn't anyone from Versailles or Versailles' side of the transaction?
That's correct.
And when a contract or a deal is submitted to Trinity Title, it comes in as a new order, true?
Yes.
And so here we see on February 9th, Ms. Rubeck gets a new order, correct?
Yes.
And that was submitted from the Zatoons or their counsel, right?
Yes.
And it was actually submitted, if we look at, this is Exhibit 125, by the way. If we look at the submission page, which is part of this exhibit and marked page 1383, we see that this was submitted by Jonathan Scott, correct? You see that on the middle of the page? And when Mr. Scott submitted this order to Angela Rubeck, he submitted a TREC contract, didn't he?
You know, I'm not positive about that. I know that we got the mediated settlement agreement. That's what we received at first. And I thought my recollection would be that the TREC contract came in, the TREC form that's on the screen right now came in maybe a few days later. But
well,
if you
Mr.
said,
Lang, Mr. Lang, if I represent to you that that's exactly what's attached to Ms. Rubeck's email is this TREC contract, you wouldn't dispute that, would you?
No, that's entirely, it just wasn't my recollection. In fact, I don't think this was, I think what was brought to my attention was the mediated settlement agreement because it's not typical. In other words, our folks know what to do with the TREC form.
And you can see from Ms. Rubeck's email, there were a number of attachments to this new order that came in from Mr. Scott, right?
Yes.
And part of that was let me scroll up, a statutory buyback that you've referred to it as, correct?
That's what I'm familiar with right there.
And that was attached to her email, true?
Yes.
And when you scroll down and look at what Mr. Scott attached to that, he attached a legal description showing only lot 3 and 4, correct?
I don't remember what Exhibit A was, but I've no doubt that this Exhibit A was attached to whatever was submitted.
Okay. And after this was submitted, you reviewed both the TREC contract and the settlement agreement, correct?
Yes.
Okay. I'm going to show you your email, which is part of Exhibit 125 and Bates numbered 1360. If I can get there, give me just a second. Here we are. Okay, this is an email as part of Exhibit 125 from you to Mr. Scott at both of his email addresses, and you're saying, I've reviewed the TREC form and the settlement agreement, correct?
Yes,
So Mr. Scott had submitted to you a TREC contract and the settlement agreement, which we're referencing, true?
I think so.
And the settlement agreement, as we saw, had an Exhibit A, including lots 3 and 4, correct?
I think that exhibit you showed me did, so I bet you're right. Yes.
And the TREC contract he submitted to you doesn't say Versailles, Dallas, Inc. and or assigns, does it?
Correct. It just says Versailles Dallas Inc.
And that's even though the buyback agreement that we were just looking at says and or assigns on
Yes.
section 3, correct?
Correct. Yes.
So his TREC contract that he submitted didn't match the buyback agreement as far as who the party was that was going to obtain title, right?
Those two documents don't match. You're correct.
Okay. And when you were testifying earlier, I was a little bit confused. Is it your testimony that the parties to the assignment needed to be Versailles and the Zatoons, or Versailles and 2808 Maple Springs?
Well, the form that I submitted, and we keep talking about the assignment, I want to make sure that that form that I circulated is an assignment and assumption agreement. It requires both, like the assignor and the assignee both have to agree, or that agreement doesn't work. So my understanding of assignment and assumption would require both parties, both the assignee and assignor, to sign the same agreement.
Right, and that's my question. So we know that Versailles had to be on the assignment. Who had to be the other party to the assignment that you keep referencing?
I don't know.
Was it the new third party?
Maybe I'm struggling with the part about when you say who had to be. I don't know. I don't know who. In other words, we don't make the contracts. We just receipt them and we go with them. So if the parties are talking about, hey, we want to do an assignment, I'm sure that I just said, sure, let me send you an assignment assumption agreement. Y'all fill it out. I didn't put any of the information in there. I wouldn't know what information to put in.
Sure. So I'm sorry, I didn't mean to cut you off.
No, so when you're saying like who should be, I don't know who had to be, but I would say the assignee and the assignor both need to join that agreement.
So when you say the assignee and the assignor, are you talking about the Zatoons, who are the seller, or are you talking about 2808 Maple Springs, the ultimate purchaser?
I'm sorry, I think I understand your question now. No, the Zatoons would have been the sellers, and then the assignment assumption agreement, that was on the buyer side of the transaction. So the assignee the assignor would have been Versailles, and the assignee would have been whoever Versailles assigns it to. So in this case, 2808 Maple Springs LLC.
Okay, so you needed a assignment from Versailles to 2808 Maple Springs in order to assign the agreement, correct?
Objection, Your Honor. The counsel's been objecting that he's not an expert witness and now asking for expert opinions as to what was required.
No, Your Honor, I'm just asking what the title company would have required to close this transaction. He's already testified that an assignment was necessary. We're just trying to figure out who the parties are.
Well,
You can testify just about what happened, what would have happened in this case, not other cases.
okay. In this case, if the contract were assignable, then we would need an assignee and an assignor, and we know the assignor would have been Versailles, Dallas, and the assignee, we would have needed 2808 Maple Springs LLC or another or whoever that they wanted to assign it to. We would need to know who that is prior to us being able to close it.
And you knew, and isn't it true, Mr. Lang, that Trinity Title received a assignment from Versailles to 2808 Maple Springs?
I believe we did, yes.
Okay, let's look at, give me a moment, I'm going to find it, because I believe your testimony, Mr. Lang, and I may have misheard you or written it down incorrectly, but I thought you testified that you did not ever see an assignment.
Well,
I'm just asking you right now what your testimony was, Mr.
yeah,
Lang.
I'm sorry about that. I don't recall receiving a fully executed assignment assumption agreement. I may have, because there's about 1 million documents that fly around, but I don't think, as we sit here right now, and I could be wrong, but I don't think that I've actually gotten that.
Okay, let's see if this refreshes your recollection. Let's see. This is
Sure.
an email from Mr. Lambert to a number of people, including you, right? You're on this email chain.
Yes,
And it says, Lori, attached is the executed assignment of the purchase contract from Versailles Dallas Inc. to 2808 Maple Springs, correct?
yes,
And for the record, this is Exhibit 129, and it's Bates number 8067 to 8071.
So I'm sorry, Ms. Pettit, could you say that again?
Yes, this is Exhibit 129, Bates number 8067 to 8071. And the attachment, Mr. Lang, is a fully executed assignment and assumption agreement signed by Versailles Dallas Inc. and 2808 Maple.
I have no reason to believe I didn't get that.
What date was that email again? I'm sorry.
Yes, Your Honor, this was March the 4th, so 4 days before the closing
Okay.
date. You don't dispute receiving this, Mr. Lang?
Not at all.
Okay, and this as, well, let me go back to your email thread because you referenced an email where you said that you sent a draft or you sent a generic version. Is this your email you were referring to where you said
Yeah.
on the 4th, you said I have a generic assignment and assumption form if anyone would like something just to get the ball rolling. Do you see that?
Yes.
And
And
then,
I think that form is my form. It looks very familiar, and I think that
looks familiar, right? You got an executed version back of the form that you had suggested, correct?
Yes. And like, for example, my form that I sent over probably would be blank as to the actual parties, but it would have a effective date and it'd have that section. All those things would be blank.
And all of this has been filled in, signed, and sent back to Trinity Title, correct?
It looks like it has, yes.
So by the 4th of March, Trinity had a fully executed assignment and assumption agreement between Versailles Dallas Inc. and the third-party purchaser, Maple Springs LLC, 2808 Maple Springs LLC, correct?
We had that agreement. That's correct.
Okay. And now I want to fast forward to, give me just a second. I'm trying to get the right documents up.
Sure.
But I want to fast forward to the 8th of March, which was the closing date, right?
Yes.
Okay, give me just a minute. Okay, so we fast forward to the 8th. Miss Chris pops up again, and she's saying to myself and the people on our side, the question was, have the Zatoons approved the revised HUD? And she says they have not. You may want to reach out to Jonathan Scott as they do not agree with deed from sellers straight to 2808 Maple, correct?
Yes.
And so is it your understanding that as of that date, the sellers were the ones that were not agreeing to allow the transfer to happen directly to 2808 Maple?
I think that oversimplifies it, but in other words, I don't think that's the only problem, but it looks like Lori, she was the escrow officer. So she would actually be on the front lines, because like she would come to me if there were problems. But
And isn't it true that earlier that date you had said seller, being the Zatoons, would have to agree to that since the contract was not made to buyer and or assigned? Didn't you say that?
Yeah, I did say that.
And you were referring to the Trek contract, weren't you?
I probably was. Yeah.
And that's the one that Mr. Scott submitted to you, right?
I don't know who submitted it, but it's that one that you showed a minute ago. So yes.
Okay. And that's even though the settlement agreement had assignment language on there, correct?
I think that's correct.
So when you looked at the contract on the 8th, you said seller would have to agree. And then at the end, you say there's really no problem for us to do that, correct?
Right.
Because you guys aren't going to stand in the way. If the contract wants to be assigned and everyone agrees, you guys want to get the deal closed. True?
Yes. Yeah, exactly.
Okay. So if this deal wasn't closed, it was at least in part because, as Ms. Chris says, the sellers were not agreeing to the deed straight to Maple.
That is correct. That's what Miss Chris says.
You were asked about doing a double closing from Versailles to, excuse me, from the Zatoons to Versailles, and then from Versailles to 2808 Maple. If we did that in this instance, two separate title policies would have to be purchased if we were doing a double closing, correct?
Absolutely.
Okay. So you can't do a double closing and just pay for one title policy, can you?
Correct.
Mr. Lang, it would be possible in this particular instance, and I'm not asking you as an expert across the board, but it would have been perfectly possible in this particular instance for the HUD to be signed and then the funds to be wired to the title company, correct?
Speculation.
Overruled.
Yes, I mean, it's possible to sign documents in sequential order.
Sure.
Yeah.
So it's not like the money had to be in Trinity Title's account in this instance in order for a HUD settlement statement to be signed. True.
That's correct.
All right, I pass this witness, Your Honor.
Few questions, Your Honor.
Okay.
Mr. Lang, counsel just asked you about the double closing.
Yes.
And so can you give us an idea if Versailles had gone forward and done that double closing and purchased two title insurance policies, what is the incremental or additional cost approximately for that extra policy?
It would be just another title policy, and on $1.3 million, if I had to ballpark it, I'm thinking that's about a $6,000 policy, something like plus endorsements. I don't really know exactly what I've got this little rate card in front of me that could get me pretty close. Hang on one second. Yeah, I think it would be almost $6,000.
And so, Ed, are you telling the court that Versailles could have closed the deal the way that the Zatoons wanted them to close it, and the total additional cost that would have been involved was about $6,000, the incremental cost difference?
Objection, it misstates the testimony. He already said there could be other closing costs and endorsements.
What would be the approximate total closing cost to do a second closing?
Yeah,
If you know.
yeah, I'm thinking. I would guess it's probably something more about like $7,500 to $8,000. And where I get there is taxes wouldn't be an issue, but escrow fees plus endorsements, and I don't know what endorsements would be there. Neither one of these was this didn't involve any loans, which that operates actually to kind of a big, it's hard for me to estimate without, most people get loans. So we're usually issuing a loan policy and owner's policy, and then one gets a discount. I'm not going to get into all that stuff, but the point is it's hard to say for sure exactly what that number would be. But I'm thinking it'd be about 7,000, maybe 7,500, something like that.
And can you tell us, Ed, whether or not there was a request or a requirement in or around March 5th of 2021 for you to confirm that Trinity Title would be insuring title to both Versailles Dallas Inc. and 2808 Maple Springs?
I believe, yes, I believe
Okay.
that was requested.
And so in that instance, based on that request, following your standard procedure and your statutory rate card, would Versailles and 2808 collectively have to pay approximately the same amount of title fees based upon the requests that they already had made that were outstanding?
They would be relatively similar amounts.
Okay. Now, you recall that Ms. Pettit asked you about a TREC contract and showed you that exhibit?
Yes,
Okay. My question is, that document was also referred to in other emails as a TREC form. Do you recall that?
yes.
Okay, and what is the difference between a TREC form and an actual TREC contract in this context?
Well, I tried. Attorneys that I used to work for would be kicking me if I referred to stuff as a contract because that's a term of art. So normally, if you just to be wordy about things, they would say a TREC form is what's promulgated by TREC, and there are lots of different TREC forms. One of them is the contract for the purchase and sale of 1 to 4 family homes. Other ones are farm and ranch contracts. I mean, contract is in the name, but really, contract doesn't exist until you have meeting of the minds and all that stuff. So, I mean, I would just say that the TREC form is the TREC form, at least certainly in my office at Trinity Title, is kind of the gold standard for those are the contracts we deal with 99% of the time. Other times, we might deal with something else. For example, a mediated settlement agreement, and usually in a divorce, not under a buyback statute, but things like that. In fact, even divorces, they would probably reduce it to a TREC contract because you can get them off the internet.
Okay, so if you're finished, I wanted to
Yeah,
ask.
yeah, yes, exactly.
Julie, can you please share screen and put up that document that you showed the witness the top of that you described as the TREC contract that was submitted when the title file was open?
I can look for it. It might take me just a second because I closed it out.
So Ed, do you recall that the Ms. Pettit was asking you about this document and she described it as a TREC contract? It was
Yes,
submitted to Trinity Title.
yes.
Julie, can we scroll down to the bottom where the signature lines are? I think it may be the next page. So Ed, now that I've shown you the rest of that exhibit, is this a contract? Is this a TREC contract? Or is this just a TREC form that's unsigned and not completed?
I'd say that's
A legal conclusion.
that's the TREC form, and TREC calls it a contract in the title of the document.
Did you ever receive a fully signed version of this document that Ms. Pettit has been kind enough to put up on the screen?
I don't believe we ever received anything that was signed by both parties other than the mediated settlement agreement.
And can you tell me whether or not when this TREC form is used, or let me rephrase it. Besides looking at the place where the signatures are, does this TREC form, if it's to become a contract, does it also have a place for the parties to initial each page?
Yes.
And do you see anything in this document that reflects that either party initialed any of the pages that are on this exhibit?
I didn't see it. We were scrolling through it pretty fast, but I don't think I saw any initials.
Okay. Now, Ed, do you recall that Ms. Pettit asked you about the opening of the ordering of title by my office around February 9th, I believe was the date?
Yes, I do recall that.
Can you tell us whether or not you had any indication that as of February 9th, that there wasn't a sign, that there was any such entity or party that was in place Was that ever communicated to Trinity Title at that time?
I don't think so.
And so, Ed, was it the case that there came a point in time, and I just want to highlight what the time frame was. Was there a point in time around right before March 1st when Trinity Title was contacted for the first time by Kenneth Lambert?
I don't recall. I've never spoken to Mr. Lambert. I don't think so. He may have spoken with either Lori, Chris, probably would have spoken with Angela. She was his assistant. She was Lori's assistant. But I personally didn't speak to Mr. Lambert, and I don't recall when the assignment issue arose.
Okay, so as a result of that, would it be fair to say that when counsel asked you a little while ago whether or not the submission by the Zatoons to the title company corresponded with the TREC form, and she showed you the settlement agreement, that you're not sure whether or not it did or it did not at that point in time?
No, that's correct, that I do not have a recollection. Again, this is, we were excited to have a big contract. We were just excited to receive it and get it underway as soon as possible.
And so, to the best of your recollection, at the time that the statutory buyback was first sent to the title company, which makes reference to Versailles buying back the property and a deed to Versailles and/or signs, the title company was not aware of any assignor being involved in this transaction.
I think that's correct. I can't say for sure what Lori or Angela knew, but from my standpoint, I think that is exactly correct.
Your Honor, I pass the witness.
Anything else, Ms. Pettit?
Just briefly, Your Honor. Mr. Lang, you said that if there was a double closing, I wrote down, you said, quote, taxes wouldn't be an issue. Were you referring to property taxes?
Yeah, I'm sorry about that. The ad valorem property taxes, what I'm getting at there is that we prorate taxes between the time that the buyer or seller owns it. So if we did a same day close, if the buyer took title in the morning and sold in the afternoon, there'd be at most 1 day of prorated taxes, which would be negligible.
Sure. And the reason why I asked Mr. Lang is you're not purporting today to tell the court whether or not this was creating a taxable event for Versailles. Were you?
It is no.
It certainly could. It certainly
if I
could
ever
create a
mention
taxable.
taxes, only property taxes. I'm not a CPA, or I'd get you in trouble giving tax advice.
So if this was going to create a taxable event for Versailles to do a double closing, you're not making any statement to that effect, correct?
It could be a taxable event. That would not be our concern. We'd tell the parties we're not CPAs, so we don't give tax advice.
All right. No further questions, Your Honor.
Anything else?
Your Honor, I call Sam Elchami.
Well, do you want to let Mr. Lang
I'd like
go?
to excuse Mr. Lang with thanks. Yes.
Thank you. Good luck, guys.
Mr. Lang, you are excused. Have a good day.
Appreciate it.
Your Honor, can we perhaps take a 10-minute break?
Sure. Let's take a 10-minute break.
Thank you, Judge.
Judge, are you gonna be okay if I go ahead and leave?
Yeah, let me just chat real quick with you about Friday, though, before you go.
Yes, no.